ourselves for the rigorous and elevating discussion that we're about to have. Friends, the National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the Constitution on a nonpartisan basis. And that mission is well served by today's program. It is the launch of our Constitution drafting project. Thanks to the vision of our friend Jeff Yaz, we have commissioned 2 teams of America's leading libertarian and progressive scholars to draft a constitution. And their homework assignment, which they chose to accept, was either to draft one from scratch in a state of nature or to revise the existing constitution so it embodied libertarian and progressive ideals. I should say that we also have a similarly distinguished team conservative. They will be submitting their constitution at the end of the month. We are tonight going to present to you the libertarian and progressive constitutions. We'll talk about what's in them, and then we'll compare and contrast. And then you, ladies and gentlemen, will vote. We, the people, can make our own decision about which constitution better aligns with your ideals. So listen closely to the options presented to you, because you'll be taking a vote of unimaginable historic consequences at the end of today's program. So I'm really excited to present our teams, and we're going to begin with Team Libertarian, and they'll present for about a half hour, and then we'll turn to Team Progressive, and I'll introduce them then. Team Libertarian is headed by Ilya Shapiro. He is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and publisher of the Cato Supreme Court Review. He's the author of the new book, Supreme Disorder: Judicial Nominations and the Politics of America's Highest Court, and a frequent guest on our We the People podcast. Christina Mulligan is Vice Dean and Professor of Law at Brooklyn Law School. She has also taught as a visiting associate professor at Yale Law School and a visiting scholar at the Georgetown Center for the Constitution. Her scholarship has been published in many journals, including SMU Law Review and Constitutional Commentary. And Timothy Sandefur is the Vice President for Litigation at the Goldwater Institute's Scharf Norton Center for Constitutional Litigation. He also holds the Duncan Chair in Constitutional Government. He's the author of several books, including Frederick Douglass, Self-Made Man, Cornerstone of Liberty, Property Rights in 21st Century America, The Permission Society, The Conscience of a Constitution, and The Right to Earn a Living. Thank you so much for joining us, Ilya Shapiro, Christina Mulligan, and Timothy Sandefur. Let us jump right in. I can screen share the Constitution and the really clarifying explanatory statement, all of which our friends can find online at constitutioncenter.org. But I just want to begin, Ilya. You were the George Washington of this project, if not the Madison, the convener and herder of cats. Tell us, what was it like to draft a libertarian constitution? How did you decide to revise the existing one rather than to draft one from scratch? And how long did it take you to agree?
Sure. Thanks very much, Jeff, and thanks to the National Constitution Center and Jeff Yass for facilitating, creating, and engendering this project. It was fascinating to do, and I was honored to have been selected to lead up Team Liberty. This was, we like to think, an easier project for us than for our progressive or conservative counterparts, because the current United States Constitution, we think, is fundamentally a libertarian, or more precisely, a classical liberal document, a product of that Enlightenment age in the late 18th century, as amended, of course, or completed or perfected by the post-Civil War amendments. And so much so that we joked that all we needed to do was to add, "and we mean it," at the end of every clause. That's the only amendments that the current Constitution really needs. The dividing of government horizontally among the 3 branches of the federal government, vertically in a federalist system to secure the blessings of liberty. And then, of course, as I said, the Reconstruction Amendments further advanced that project by extending the Constitution's very libertarian guarantees against state violation, including, of course, eradicating slavery, the single greatest contradiction to this libertarian ethos of the American experiment. We added some things based on the learnings from the last 230 years, such scholars as Randy Barnett and Milton Friedman, allowing states to reject or eliminate certain federal laws or regulations, adding a balanced budget amendment, adding other protections from state constitutions. My colleague Tim Sandefur has a great knowledge of state constitutions, and so we borrowed certain things, again, to limit government, to protect liberty maximally. And we did a lot of technical fixes, so random capitalization and word usage, as well as, since we have a new constitution, there's no amendments yet, so we incorporated the existing amendments, at least those that we liked, into the main body of the Constitution. But you're not going to find the 16th, the income tax, the 17th, the direct election of senators, or the 18th, alcohol prohibitions, because those are don't facilitate that. And we tried to avoid changes or structures that were purely good government reforms without clear libertarian salience. So, for example, adding term limits either to members of Congress or Supreme Court justices may be good ideas, worth debating from a political science perspective, or expanding the size of the House or the Supreme Court, for that matter. Very interesting academic discussions, not necessarily libertarian, so we stopped. We didn't engage in that. And fundamentally, we focused, as the original Constitution's authors did, on protecting negative rights, rights against being interfered with, instead of creating positive rights like the right to education or healthcare or other things that have to be provided by others. That's it. It wasn't, it was condensed into about a month after I had to submit my manuscript for my Supreme Disorder book on the politics of nominations until this was due at the beginning of May. But we had several Zoom calls and just hammered it out. And both Tim and my other colleague, Christina, added excellent felicitous language in various parts that I hope we'll get to discuss.
Inspiring. The framers took 4 months or so, from May to September, and you did it, it sounds like, in a few weeks, and a very inspiring document it is. My first question, I want to just put on the table the main provisions that you've suggested. You have many important suggestions regarding structural guarantees of the Constitution involving Congress and the states. You rewrite the Commerce Clause to make clear limitations on congressional power. You address the Declare War Clause, emphasizing Congress's role in authorizing military force. There's an Ellis Island Clause providing for a more liberal immigration policy. You limit the sweep of the Necessary and Proper Clause, which is the clause that gives Congress unenumerated powers, and much more. So I'd like your teammates to discuss the important structural suggestions that you make. And as team leader, Ilya, who do you think should best take that, Timothy or Christina?
Christina, why don't you start off? And I should also add, because I've gotten comments already, that a lot of libertarians are concerned about the postal service. So we kept the power of having a postal service, but took away the monopoly. So that's how we finessed that particular parochial libertarian concern. Anyway, Christina, yeah, go ahead.
Yeah, so we kept the structure of the original Constitution as amended by the Reconstruction Amendments, porting those changes into the main document where necessary. But most of the major changes that you just described, Jeff, are more about clarifying or returning the powers or structures of government to what they originally were or meant. So the Commerce Clause, the earlier cases kind of held that it actually needed to be commerce, and it actually needed to be between the states. And we reclarify the language to return to that because we think that's the proper role of the federal government. Similarly, the Necessary and Proper Clause, instead of being the mouse hole that you can drive a train through, returns to being a tool to help Congress enact incidental rules that advance the powers that are actually explicitly delegated to it. But what I think is most important about the project as a whole is that it instantiates the values of liberty and freedom that the three of us and other people that might self-identify as libertarians really hold dear. And I think part of why, as Ilya said, it was relatively easy for us to discuss what to change and what to keep was because we shared a common philosophy about what the proper role of government was for a flourishing human life. So some of the changes that we added, maybe you would call them structural, or maybe you would call them just clarifications of rights, hone in on those values, right? So free markets and free movement, very important to the project of liberty. And so we have essentially, although Congress can make regulations to make the process of immigration or coming into the country regular, essentially the Ellis Island Clause, as we put it, allows anyone with peaceful intent to come to the country to make their way. And we think that's important to the values of liberty. And similarly, one of the, it's a small change, but in addition to what was the First Amendment, but now is Section 1 of a new section in the Constitution, notes the importance of the freedom to lead a peaceful life of one's choosing and freedom of conscience. And that language is important because one of the most important parts of being a human being is trying to figure out how to live your own life without the structures of other people telling you how to do it. And we wanted to make this Constitution inclusive of people whose values might be as varied as evangelical Christians, Muslims, atheists who live in a free love commune. Whatever your version of the good life is, if it is peaceful, if you can coexist among others, that's something we wanted to explicitly say was something that we wanted to include these values of tolerance and of being able to live within one polity with these limited structural boundaries on how to organize ourselves amongst each other. I think the other major thing that we tried to do, and interestingly, the Progressive Constitution also does, is try to rejigger the balance of power both horizontally and vertically. So vertically between the federal government and the state governments, and horizontally among the different branches. So we make some small changes to Article 2, specifying not that the president has executive power, which has been argued about as potentially vague, as to possibly giving more expansive powers, but to say the president can execute the laws, being more narrow and giving more or returning more power to Congress. And similarly, we undo South Dakota versus Dole, allowing for the federal government to condition tax dollars taxed from the state being given back to the states on federal requirements. So again, replacing power to the states, not letting the requiring those tax dollars to be given to the states without those regulations being followed through. So the values there again are trying to rebalance power in order to create a government that is more likely to protect liberty. And I think, there are countless examples of where those particular choices may or may not work all the time, but our goal was to try to create a system, as the founders originally did, where parties are jealous of their power, where they combat each other, and where the result is not a concentration of power that can be very liberty defeating.
Thank you so much for that very comprehensive discussion of many of the structural provisions that you embraced, as well as noting the connection between structure and rights in the case of freedom of conscience. Timothy, it would be great if you could give our friends an overview of the main suggested changes you've made for the Bill of Rights. You, for example, add a right to make political contributions to the First Amendment. You eliminate the preface of the Second Amendment, the well-regulated militia clause, to make clear that it's an individual right. You emphasize protections for personal privacy in the Fourth Amendment, adopting, you just told me, from a state constitution that I'd love for you to tell our friends about. You strengthen the takings clause and much else. So give us the overview of the changes to the Bill of Rights.
So as Ilya said, a lot of what we did was basically, and we mean it. And so a lot of what you've just mentioned, for example, are things that we think are already protected by the federal Constitution when properly interpreted, but that unfortunately both courts and law professors and lawyers often misrepresent or distort. And so things like clarifying that the Second Amendment does mean an individual has this right. It's not some kind of a collective right that's of the whole people, and clarifying that the freedom of speech does include your right to contribute money to a political campaign that you support, which is already protected by the First Amendment, but many people deny that it is. So we added many of those things simply to clarify what we believe to be existing law. But with regard to, for example, you mentioned the search and seizure clause, we changed that one substantively. And what we did there was we borrowed language from the Washington State Constitution, which protects the right of a person to his or her private affairs. This is language that is unique to the Arizona and Washington constitutions. Washington put it in its constitution in 1889, and Arizona included it in its constitution when it was written in 1910 and revised in 1912. So that provision was written, well over a century after the First Amendment, with the idea in mind of the Fourth Amendment, the idea in mind of protecting individual rights against warrantless searches and against other intrusions into private affairs. And so the idea being that this would guarantee not only your right to not have your home searched, but also your right not to have the government demand certain information from you. Washington courts have interpreted this provision in its state's constitution to provide some of the strongest protections in the country against warrantless searches, including warrantless searches of digital information like your cell phone information and things like that. So we decided that that was a good idea to include that in our state constitution, or in our federal constitution. And we did that throughout the document. We often forget that America has not just one constitution, but 51 constitutions, and that the states have all revised their constitutions extensively throughout American history in order to address new and dangerous threats to individual freedom that arose after the United States was founded. So there's no reason not to borrow from their experience in protecting our rights in the federal Constitution today.
Thank you so much for all of that. And of course, the precise language that you chose is crucial. And I'm going to try to screen share and see, I hope I'll be able to, but on the thought that it may be helpful. And then Ilya, we have sort of one round of for each of you before we turn to Team Progressive. So I'm going to ask you, as I turn to my screen sharing, which provisions you would like to emphasize. For example, you do have a new conception of the judiciary and the presidency in important ways, and tell our friends about how you have rethought the presidency and the courts, as I see if I can call up the language.
Christina has mentioned this. We want to make sure that the executive power isn't some nebulous, broad, ever-growing ratcheting up of power that every president grows. It's to execute the laws, and so we've tried to clean up the appointment power, to specify that treaties can't expand congressional power. We've even reined in the State of the Union, if we will, making it requiring it to be transmitted in written form as it was until Woodrow Wilson. Congress can, of course, still invite the president to make a speech, but we wanted to clarify that only the writing is necessary. But I'd say that the most important parts are some of the biggest ones that have been warped over the decades, and that's the General Welfare Clause. It's Section 8 of Article 1, the powers given to Congress, specifying that the General Welfare Clause actually refers to the general as opposed to parochial or specific welfare, not simply a majority in Congress. That's not enough. It has to be for the general welfare. The Commerce Clause has to regulate actual interstate, actual commerce. So non-commercial activity cannot be regulated, and wholly in-state activity cannot regulated, with one exception. We do allow for the regulation of interstate pollution. This is one thing when people ask me, what federal power do you think the government should have, that it doesn't? And I'd say an environmental regulation of certain kinds, when it's truly flows interstate, either via water or pollution in the air or what have you. And then, as Christina mentioned, the necessary and proper clause to make this just allow laws that are incidental to the enumerated powers, not just new ones that is an endless string of knee bone connected to the shin bone. As far as the judiciary is concerned, we just want the judiciary to be an active participant in this. And whether you call it engaged or there's different terminology, but we want the entire Constitution to be enforceable by judges. And let's have that debate over whether they're interpreting it correctly or not, rather than, are they being restrained or activist or what have you? Just what is your theory of interpreting this and definitely apply it, whether it's the guarantee of a Republican form of government, whether it's weighing in on the general welfare or commerce clause. We want the judiciary definitely to exercise its power of judicial review, because at the end of the day, that particular check and balance is there to promote individual liberty in potentially unpopular counter-majoritarian situations.
Thank you for all that. I'm so excited to actually have the text before us because it really is so clarifying. And Christina, on the judiciary point, I think you talk about a method of interpretation and original public meaning, and we'll see if this sort of scrolling sharing works, but are there other particular provisions and specific language you'd like to call out and read to our audience?
Yeah, so I think a bit later we have we specify that the Constitution should be interpreted according to the original public meaning at the time it was adopted. In this case, it would be now, if we were adopting this now. And, I think we have different reasons for, the reason I've always been attracted to that brand of originalism is the simple reason that that's essentially how law works. When you're interpreting any statute, any piece of law, you look at the meaning of the language at the time that it was written, as opposed to if there's been a semantic shift over time. But I think the most perhaps controversial decision we made that's structural, which might be interesting to talk about, is the returning more power and discretion to the states. So one thing we don't do is eliminate the Electoral College, nor do we mandate that electors are chosen by popular vote. We keep we maintain the current rule that states can choose electors any way they want. Similarly, we remove the amendment that allows for direct election of senators. And this was a challenging one. This might be the one thing that we were kind of debating about what was most liberty enhancing. And so I think we're not as passionately wed to that choice as maybe we are to others. But the thought process was that there have been different times in history where the federal government or the state governments were better situated to be the protectors of liberty. Post-Civil War, it was more the federal government, and you see power flow up. But we tend to agree that power concentrated in smaller jurisdictions tends to be more responsive to people, and so tends to be more likely over time, in a general sense, to be liberty enhancing. And I think maybe in seeing the federal response to the coronavirus, we can see how the relative weakening of states compared to the strengthening of the federal government, which makes it more difficult for states to get resources to tax relative to the amount the federal government taxes, et cetera, has put the states at a disadvantage at a time when the federal government wasn't acting as dramatically as a lot of states would want. So, our conclusion on balance is that smaller jurisdictions tend to be more protective of their own people than larger ones. Though, of course, throughout time, that's going to, shift a bit depending on circumstances.
Thank you so much for that. Timothy, this is the last round of the initial Team Libertarian presentation. I guess the broad question I'll ask is, how dramatically would America change if your Constitution were adopted? Do you see it as a clarification and incremental refinement of the existing Constitution, or would the structure of the federal government, the administrative state, and the nature of the protection of liberty be dramatically transformed?
That is a tough question, because I think there are many respects in which it would change hardly at all. There are other respects in which it would be a big change, but by liberating people to solve problems for themselves without being guided, controlled, and overseen by a massive bureaucracy in Washington, D.C., I think that people would find private solutions to the problems that would arise much more rapidly than they do under today's system, where you have to obtain government permission to make changes and innovations in so many ways. So I think, although there would be some respects in which this would be a large change, I think that the system would counteract for that, and people would solve these problems freely. Libertarianism never says that that the market will solve all our problems. What it says is that the market will allow people the freedom they need to solve all their problems. Whereas people on the left or the right tend to say that if you give government the power, it will solve all of our problems. And that's virtually always a lie.
Thank you so much for that. And there is one point that I wanted to call out before I thank the team. Tell us about how your constitution would check tribal governments, because that's an unusually interesting innovation.
So that was a provision that I suggested because, Native American tribes enjoy sovereignty and government authority. And in many respects, they have said that they would like more sovereignty and government authority. And our proposal is to enable them to exercise that authority, but within the boundaries of constitutional protection. Ever since 1924, when Indians were made citizens of the United States, as opposed to being treated as foreigners as they were before, they should be entitled to the same constitutional protections that all other Americans are against their tribal governments, the same way that you and I are protected against state governments. Unfortunately, although Congress passed an Indian Civil Rights Act that was intended to accomplish that, the Supreme Court basically nullified almost all of the Indian Civil Rights Act in a Supreme Court decision in the 1970s. So what we've done is we've gone in and we've overturned that by saying that states and tribal governments are, for the most part, treated the same under our federal constitution, so that you are guaranteed certain rights against tribal abuses. There's one notable exception, which is that we allow tribes, but not states, to establish official religions, because of course an official central religion is a large part of what it means to be a tribe. So we allow them that authority. But things like search and seizure or the taking of private property, people who live on reservation or are subject to tribal government authority should have the same constitutional protections against those governments that you and I enjoy against states.
Thank you so much, Team Libertarian, Ilya Shapiro, Christina Mulligan, and Timothy Sandefur for a superb presentation of the Libertarian Constitution. And I will now welcome Team Progressive. And they will magically appear on Zoom as I introduce them. Carolyn Fredrickson is the leader of Team Progressive. She is a visiting professor at Georgetown Law School. She served as the president of the American Constitution Society from 2009 to 2019, where she collaborated closely with the National Constitution Center and is a great friend of our programs. She is the author of Under the Bus: How Working Women Are Being Run Over, The Democracy Fix, How to Win the Fight for Fair Rules, Fair Courts, and Fair Elections, and most recently, The AOC Way. Jamal Greene is the Dwight Professor of Law at Columbia Law School. He's the author of the forthcoming book, How Rights Went Wrong: Why Our Obsession with Rights is Tearing America Apart. He has been a senior visiting scholar at the Knight First Amendment Institute and currently serves as co-chair of the Oversight Board, an independent body set up to review content moderation decisions on Facebook and Instagram. And Melissa Murray is the Frederick I. and Grace Stokes Professor of Law and faculty director of the Birnbaum Women's Leadership Network at New York University School of Law. She's an author of Cases on Reproductive Rights and Justice, co-editor of Reproductive Rights and Justice Stories. Her publications have appeared in many law reviews, and she's also written for publications from the New York Times to the Washington Post, and appears frequently on NPR, CNN, MSNBC, and PBS. Thank you so much for joining us, Carolyn Fredrickson, Jamal Greene, and Melissa Murray. I will start with you, Carolyn. Congratulations and thanks to you for leading such a distinguished team. Same question as I began with to Ilya. What was the process by which you deliberated, and how long did it take you to agree, and what are the core elements of the Progressive Constitution?
Well, first of all, thank you, Jeff, so much for this whole enterprise. It was a tremendously stimulating and exciting project. And thanks to Jeff Yass, who has supported it so wonderfully. And then of course, my partners, I don't know if I could call myself the team leader. We are a team. Melissa Murray and Jamal Greene are not only extremely brilliant scholars, they are warm and wonderful individuals, and it was just a joy to work with them. So I feel tremendously honored to have had the privilege of doing that, as well as the many, many people that we talked to along the way. And so, Jeff, to your question about our process, Melissa and Jamal and I have been talking for a long, I guess, since pre-pandemic, when we first engaged in this along the way. And I have to say, I don't think we ever had any major disagreement about the direction to go in. We really worked things through together. We came to this originally with the big question of how do we approach the project of writing a progressive constitution? Is that something that we want to do by starting from scratch? Or should we approach it in with the sort of a more modest understanding of working on something that would be really relevant to today's debates, and to try to address some of the major flaws of the Constitution as it exists? And with that in mind, we did, much like Team Libertarian, keep much of the basic structure of the Constitution, but our real goal was to direct our main focus to the failures of democracy under the Constitution as currently constructed and or interpreted. And so we really wanted to emphasize the structural Constitution and changes to the structural Constitution more than we really focused on fundamental rights. And I think for many people, they will think that is the opposite of where progressives might normally focus. The stereotype is that we look to the courts to develop a fundamental rights jurisprudence, and rather than looking at the structures of the Constitution. We actually understand the structures of the Constitution as fundamental themselves in ensuring that the rights can be realized and respected. And thus, we think the most important thing is embedding in the Constitution a much more firmly democratic structures. And the democratic structures themselves will allow we the people, who are at the very beginning of the Constitution, are the most essential part of it, to determine what those rights are in a free and fair society. And so then before I turn over to Jamal and Melissa for any other commentary, I just want to say that in that light, our major focus in this Constitution is to ensure free and fair elections, to establish an accountable and inclusive government, to ensure an effective government, to update the Constitution where it is outdated and in need of modernization. Although we didn't go to the effort to to modernize all the language as the Team Libertarian did, but we also want to focus on establishing real equality. And we did add into the preamble the word equality to make that point even more clear. And we address fundamental rights. Again, as I mentioned earlier, we did not spend, we think that the most significant way to protect fundamental rights is through a robust democracy with free and fair elections. However, we did want to make sure that some key issues that have been debated in our country could be resolved in the Constitution. And so that was our essential exercise. Along the way, we did, all of us, as part of our inclusive progressive process, engage quite a number of scholars around the country in different institutions with different points of view, with different perspectives, to get as much input as we could, to be as thoughtful and deliberate as possible within this process. And so it was terrific, I have to say. It was a great undertaking. And again, I'm very, very grateful to the National Constitution Center to have set us on this course. Certainly for me, it was a very enriching experience.
Well, thanks to you and your colleagues for such an inspiring effort, for taking it so seriously and for so thoughtfully presenting a constitution that, as you say, really emphasizes democracy. And your preamble emphasizes, or your description says, that although some progressives question whether the core Constitution is a progressive document, you're going to emphasize its democratic aspects and perfect them in ways that you believe will fulfill its promise. There's much to say about the structural reforms you recommend. You noted some of them. The free and fair elections reforms include abolishing the Electoral College, eliminating restrictions on voting rights tied to carceral conditions, establishing DC statehood, establishing national uniformity in voting clarifications, ensuring government has the power to pass campaign finance reform, abolishing the Electoral College, creating a more representative Senate. I'd like either Jamal or Melissa to give us an overview of those structural democratic reforms. And Carolyn, as team leader, I will delegate to you the task of calling on Jamal or Melissa to start.
Well, I think this one I asked Jamal to speak to. Of course, Melissa is also expert in this area, but maybe Jamal can speak first.
Great. Thank you, Jamal.
Sure. I'll say a little bit about what we chose to do. And as Caroline mentioned, we rather than focus on particular rights, we thought that firming up democracy is the most important goal, and firming up self-governance and representative democracy is really what we're trying to do. And so we found a number of places where we thought that it was important to intervene. In some ways, maybe the most important is the US Senate, which is badly malapportioned. One thing that we did recognize, and this is part of the project of saying, we want to stick with something recognizable in the current structure of the US Constitution, is we keep federalism, right? We're not getting rid of states. We're not getting rid of representation at the state level, but we're just adjusting it so that it's much closer to being truly representative. So our Senate reform keeps one senator for every state, but adds other senators to particular states in proportion to those states' proportion of the population. So if California is 12% of the population, roughly, they get an additional 12 senators, and that goes on and on and on. So you'd have more senators in general, but those would be apportioned to states with larger populations. We would eliminate the Electoral College. We don't really see much defense of that particular institution, but in instituting a national popular vote in response, we did choose to constitutionalize ranked choice voting for president. Part of the reason to do that is to ensure that the president is more likely to be someone who's not an extremist, which, as the one national office and the one person who represents everyone, we think is quite important. We have eliminated much of the incentive for gerrymandering at the district level. So we require independent commissions, which doesn't fully eliminate districts, but does allow districting to happen on a nonpartisan basis. We allow campaign finance restrictions on the First Amendment. We don't deny that there is a speech interest at issue in campaign finance regulation, but we allow reasonable regulation of campaign finance. One thing that I think is also quite important to mention as we think about representative structures, not just the District of Columbia, which we guarantee statehood for, but also residents of federal territories are given an opportunity of self-determination at regular intervals, either to become a state or to become an independent nation, so that there aren't just these permanent second-class citizens within the country. I think some of the other parts of the Constitution that don't directly relate to free and fair elections also do relate to making sure that, consistent with the Madisonian vision of separation of powers, that no one institution becomes too powerful. And that includes the executive. We've made impeachment easier. We've said that the executive power can be limited by law, so limited by Congress or legislation. We allow for legislative vetoes. And we limit the judiciary as well, so that the judicial branch is term limited, that the judicial branch, when it finds rights, is also chastened by a limitations clause, so that the finding of a right doesn't in all instances overcome any democratic effort to try to reasonably regulate that right. Last thing I'll mention, consistent with trying to make this a document that can last and that is flexible, is to change the amendment process so that it's not just 2/3 of the states, 2/3 of Congress, and then 3/4 of the states, but also has an option for 2/3 senators representing 2/3 of the population, or representatives representing 2/3, and then states representing 3/4 of the population, so that if overwhelming numbers of the American people support an amendment, it has the possibility of being passed.
Thank you for all that and for emphasizing those provisions which enhance democracy in the ways you describe, and that amendment provision is central. Melissa, if one of your central themes in your progressive constitution is democracy, the other, of course, is equality, and that appears in your revised preamble, where you talk about securing the blessings of liberty and equality to ourselves and our posterity. Beginning with the Declaration of Independence, you tell a story of increased equality through constitutional amendments, new laws, and new court decisions. And you would enshrine, as a matter of constitutional text, court rulings. You would write women into the 15th Amendment. You include an Equal Rights Amendment that explicitly guards against discrimination based on gender, sexual orientation, gender identity, pregnancy, and childbirth, and protects reproductive rights. And you extend equal rights to residents in federal territories. There are many other equality enhancing provisions. Perhaps you could give us a sense of what role equality plays in your constitution.
Sure. And again, thank you, Jeff, for including us in this project. This was a really terrific thought experiment and lots of fun to sort of abstractly think about how we might start over or not. And ultimately, we came out to the view that starting over was not something that we thought was consistent with a view of progressive constitutionalism, that the bones were there, but what we really wanted to do was enhance those bones and, again, make them more democratic and more reflective of the population and of the people's will, essentially. So as you say, in order to enshrine the guarantees of liberty, we started from the premise that the original text of the Constitution did not really speak to equality. So we wanted to make that explicit from the start. And that though the postbellum Reconstruction amendments abolished slavery and sought to include some members of the African-American community in the polity, did not include everyone. So even though there were these explicit steps to be more mindful of equality, they were not completely comprehensive. So recognizing those limitations, we wanted to enshrine equality gains that had been made both by legislation and by court decisions into the text of the Constitution itself. As you have noted, we expanded the understanding of the 15th Amendment. I think it's renumbered as the 14th Amendment here, but it explicitly contemplates women as franchise holders. To that end, the 19th Amendment, which was originally the amendment that included women as franchise holders, has been transformed into an Equal Rights Amendment that provides explicit constitutional protection for pregnancy and childbirth and all attendant conditions, which could be lactation and things of that nature. And we also defined it to include the decision to become pregnant as well as the decision to terminate a pregnancy, to sort of encapsulate the full scope of reproductive rights and justice concerns that might be attendant in those decisions. And of course, we have provided for an opportunity for members of the territories to become fully included in the polity as part of the democratic scheme of this. We also added some explicit protections for fundamental rights to deal with the liberty side of this equation as well. And we recognized from the outset that most people probably expect the progressive constitution to be one that really packs in a lot of explicit protections for various rights and entitlements, maybe even does away with the Constitution's bent toward negative entitlements or negative rights in favor of positive entitlements. But we try to resist that temptation, again, on the view that ensuring and shoring up democratic participation and the institutions of democracy would be the best way of protecting individual rights. Nevertheless, we noted that there were some explicit fundamental rights protections that should be included that have already been recognized in certain respects, and we wanted to make those clear here. We also wanted to clarify the scope of the state's ability to regulate, even in the face of certain kinds of rights. So to that end, Although we protect an individual right to bear arms in the Second Amendment, we specifically contemplate state-imposed limits on that right. We have updated the Fourth Amendment's protections against search and seizure to meet the challenges of a modern, digitally oriented society. And we have recognized in both the equality provisions and the liberty provisions that sometimes the guarantees of liberty and equality are inextricably intertwined. And so efforts to address reproductive rights speak both to a liberty question, but also to that issue of equality. We made more deliberate changes to certain fundamental freedoms in the Bill of Rights. So for example, we reimagined the First Amendment in terms that reflect James Madison's original desire to protect both freedom of religion and freedom of conscience or thought. And we thought that that approach not only reflected changes in the polity, where many individuals are not necessarily religiously affiliated, but nonetheless espouse a kind of spiritual attachment or affiliation that we thought should be recognized as well. Recognizing freedom of conscience and thought also, I think, brings our Constitution in line with other jurisdictions that do recognize explicit protections for freedom of conscience, thought, and belief. We also reimagined the Ninth Amendment slightly. We were very sparing in providing for certain rights protections, but again, we wanted to ensure that the Ninth Amendment could not only provide for unenumerated rights, but that it would also include an explicit limitation clause on the exercise of all rights. And we recognize that the US Constitution has never included an explicit discussion of limitations of rights, but those sorts of clauses are features of other constitutions and other jurisdictions like South Africa and Canada. And so as a general matter, these limitation clauses recognize that rights, even the ones that are subject to constitutional protection, are not absolute. And Jamal writes about this in his forthcoming book. So that's also a great primer and part of the animus for our or the animating principle behind us thinking about it in this respect. So we've allowed for a limitations clause that allows for rights to be limited to a certain extent to promote other democratic values, including the exercise of other rights. But by the same token, a limitations clause could also prohibit excessive restrictions on the exercise of rights that may be harmful to democracy in some respects. Again, we recognize that lots of people would expect us to provide for positive entitlements here. We really, really wanted to think hard about this. And I'm not sure that we satisfied all members of the Progressive Caucus in our decision to forego the temptation to include positive entitlements. But we really felt that strengthening democratic institutions would be the best way to provide and ensure for a robust set of rights for individuals.
Fascinating highlighting of such important choices you made from very specific choices. The Fourth Amendment updating to a digital age was a wonderful draft of a challenge that many have struggled with for a long time. The adoption of the freedom of conscience language was so interesting that you went back to Madison's and Mason's Virginia Declaration of Rights. Team Libertarian, interestingly, also had a conscience provision, but you apply them in different and really significant ways. And then you ended by noting that you could have been more majoritarian. You could have been more focused on creating new positive rights, but instead you presented a kind of reimagining the Madisonian Constitution for a progressive age. So Carolyn, the goal of this round, of course, is to highlight both specific provisions and broad principles that our friends in the audience need to know about to prepare themselves for their extraordinarily important vote at the end of the evening. But maybe I'll just begin by asking, and I will call it up on the screen in a moment, why did you retain some of the anti-majorian provisions you did? You retained the Senate, for example, although you changed the apportionment. You still make it difficult to amend the Constitution. You still preserve a high level of judicial independence. Tell us about what it was that made you decide to retain those Madisonian features and what additional provisions we should know about.
Sure. Well, let me start with the Senate. We did think it was valuable to have a kind of regional representation, which is in many ways what the Senate allows, to have a perspective that comes from a larger body of land than might be represented in a single congressional district, which might really be mostly, or just part of a city, for example. And so we did think that was important. But as Jamal mentioned, we really wanted to make sure that the Senate was a more representative body, because the direction that it's going right now is that senators represent a smaller and smaller percentage of the American people. And we wanted to address that while retaining the kind of the ability to have regions represented in the Senate, and create a body that wasn't simply a kind of a duplicative of the House. And thus we, and Jamal is to be credited for this, the mechanism of allocating additional Senate seats based on a percentage of population, which then both retains the ability of regions to be represented, but also ensures that the Senate is not so skewed in favor of a small group that it ceases to be a democratic body in any sense. So we did retain it for those purposes. I think we also all agree that an independent judiciary is a critical factor. I mean, we were not, as our introduction makes very plain, the separation of powers and checks and balances that's the premise of the Constitution is something that for us is one of its better and best features, and something to be retained. And a critical piece of that is having a judiciary that is independent. How else can you check an executive, for example, that's run amok without a judiciary that's independent? And we do think that the judiciary needs to be made more independent and be less politicized. And that is one major reason why we look towards these term limits for judges, for justices, 18-year term limits, to ensure that, for example, one president who could have, for example, 4 vacancies wouldn't determine the future of the United States for a generation by appointing very young judges who would serve for a period of time that would be very much out of step with historical practice, as well as with a more robust democracy. So those are a couple of the areas we were very clear on. And so, you know, we're not, you know, clearly that this Constitution is not meant to be just a purely a majoritarian document, because the fundamental rights piece as well speaks to that. And I think, Melissa, you wanted to jump in here.
Well, I guess I just wanted to say too that we understood this exercise not solely to be about writing a new constitution, but also a sort of educational process of letting people know what progressive constitutionalism might look like, or that there might even be different strains of progressive constitutionalism. You know, I think some of your audience have noted that there are 2 constitutions that might reflect a more conservative view of the Constitution, yet there's only one view that might reflect a more left vision of the Constitution. And, you know, one of the things we wanted to emphasize that there is diversity in terms of what progressive constitutionalism might look like, even within the progressive caucus. And so our choices here and our decision to consult widely within that caucus was purposeful, to make clear, to think about other ways of doing things, and to ensure that we were weighing lots of different options. And we rejected some things, and, you know, maybe even more progressive constitution would have included them. So would have thought about different choices. But even the way the project has been framed and the way it's been visually represented, I think is really interesting. The Libertarian Constitution is represented by a picture of the Statue of Liberty, whereas the Progressive Constitution is represented by some, upraised fists. And, you know, we are fighting against the view that progressive constitutionalism is about burning it all down. And I think the 3 of us firmly reject that premise. We truly believe that the Constitution has the structure and the possibility to be a document that governs everyone, that has the ability to create and cultivate a more perfect union. And our view was to help elaborate those institutional features that would allow us to do that, not to burn it down, not to start from scratch.
Thank you very much for that, and also for that important design suggestion, which would better capture your project. Jamal, last word to you in this round. Fascinating to learn that the proposal for a limitations clause on rights comes from your book, and in your 9th Amendment, you say the Constitution guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. You note in your introduction to your Constitution that many Europeans' constitutions have similar clauses. Tell us about the genesis of that. And then please sum up in this important final round any broad principles that you want to make sure that our audience understands about the progressive Constitution.
Sure. The limitations clause, the precise language of it doesn't come from Europe, it comes from Canada. And Section 1 of the Charter of Rights and Freedoms, which has that precise limitations clause. But there are also other constitutions in Europe and elsewhere that also explicitly limit rights. Now, of course, one reaction that one often sees from Americans when you talk about limiting rights is, well, this is going to harm minorities, or it's going to be oppressive or something along those lines. But one of the things that we wanted to try to emphasize is there has to be some balance because rights can also be used to undermine democracy in various ways. Our history is a history of trying to strike that balance in the right way. And so I'm not suggesting, and we're not suggesting that we have the perfect answer to it, but we did want to emphasize that that democratic elaboration through representative bodies is one of the important ways in which we actually recognize rights. And so we want to be able to encourage that kind of dialogue. More broadly, I'll just go back to the theme of, we wanted to create not just a document that reflected a progressive vision, but a document that would be useful to people. The Constitution we have is not perfect by any stretch of the imagination, but it also has some good bones that we wanted to make sure we wanted to create something recognizable to people and usable to people, but also show the ways in which with some tweaks, we can make the Constitution more democratic, more representative, but also protect people's rights and their ability to flourish.
Thank you very much for that and for that eloquent conclusion. All right, well, it is time in our final half hour as we prepare for our vote to bring in both teams again and to explore similarities and differences in the two documents to inform your vote, friends. I want to thank you for your excellent questions in the Q&A box. I see them and am struck by them. I want the two teams to compare and contrast a bit, so I'll bring in your questions if I can, but I'm going to begin this round by asking you to identify areas of agreement between your two constitutions. I'll ask each team leader to do that, and in the hope that it's helpful, I'll just sum up some points of convergence that the National Constitution Center's phenomenal content team noted. Both the progressive and libertarian constitutions conceptually aren't trying to write on a blank slate and are building on the existing Constitution rather than completely starting from scratch. Both strengthen the protections of the Fourth Amendment, both write new protections for freedom of conscience and association into the First Amendment, both reaffirm the importance of unenumerated rights, both make clear that key provisions of the 14th Amendment, protecting equal protection, due process, and fundamental rights, apply to the national government. Both converge around the need to limit the imperial presidency. Both address the need for national power to address interstate pollution, and both have notions of constitutional reform and changes to the ratification process. Finally, I'm not sure we really highlighted this, but it's fascinating. Both of you made it clear that impeachment does not require an official to commit a crime. And although your language was different, you broadened the grounds for impeachment. So those are some areas of convergence that you both identified. Ilya, can I ask you to identify any other areas of convergence that you found between the Progressive Constitution and the Libertarian Constitution.
Yeah, I mean, I had some, and then you and your content team kept spelling them all out.
I
So
know, they did a
I
great
can't
job.
off the top of my head, but I do want to mention a couple of things. So you mentioned the impeachment power. To be clear, our language is impeachment for and conviction of treason, bribery, other high crimes and misdemeanors, or other behavior that renders them unfit for office. So we're relying on the political judgment of Congress to make the decision. And this is, by the way, not thinking specifically about Trump, more broadly about the president. We would like to see lots of federal officials impeached for all sorts of dereliction of duty in various ways. The treatment of the District of Columbia, I mean, this is sort of both a convergence and a separation. What we did was to retrocede all of DC other than the parts occupied by the federal buildings, the monuments, the National Mall, that sort of thing where nobody lives, back to Maryland, the same way that Alexandria City and Arlington County were retroceded to Virginia way back when. And so those residents of DC would get their full voting rights. Nobody lives in the federal district. And if somebody temporarily does, then they get to vote whence they came, basically. On the other hand, the progressives just made DC a state. We definitely don't want that because it would be an unusual state. And we also don't want to incentivize the further centralization of power or growth of DC sovereignty, because it's meant to be a federal enclave.
Thank you for that. Carolyn, similarities you discern between the Libertarian and Progressive Constitution?
Well, I have a bit of the same problem that Ilya has, is that you kind of ran through the major points, and I was going to emphasize DC as well. It is a point of similarity. Certainly there's a distinction in how we approach it, but I think fundamentally the idea that a group of people should not be denied democratic rights that are provided to all other Americans, I think is a key point of agreement. And I think we could certainly have a discussion about what is the best mechanism to effectuate those rights. But I think that agreement seems to me is very significant. I also just wanted to say to Ilya, congratulations on the great product placement. I think maybe we should have all thought about that before this happened. And I do, that's very, very creative. So kudos to you. But I was heartened to see that there were certainly some significant areas of overlap, even though there are obviously some key areas of difference. But it was a fundamentally interesting exercise to read the Libertarian Constitution. I think it is also, definitely worth remarking upon that we all had agreed with retaining the essential structure of the Constitution. As Melissa mentioned, it is to some extent, and to a large extent, it was because we agree with the way that the Constitution has laid out the governing structures and the separation of powers as essential to a free and democratic nation. But it was also, I think, and I'm not sure if this played into Team Libertarian, perhaps not, but it was, as Melissa has said, to make this actually a direct and engaging educational experience for people coming to the National Constitution Center to see how progressives engage with the Constitution and how it relates to current debates that are right now dominating much of our discussion about how do we protect our democracy and what are some of the challenges we face right now. We think that the way we wrote that Constitution allows people to understand where some of the weaknesses are that do need to be enhanced to ensure that we have a better and stronger process going forward.
Thank you very much for that. Well, let us now turn to the crucial question of differences between the constitutions. Although you both retain the basic structure, you have clearly different emphases, with the Team Libertarian emphasizing liberty and Team Progressive emphasizing democracy and equality. There are other broad areas. I don't mean to step on your answers by sharing the great work of our content team, so I'll just share the broad categories of difference that the National Constitution Center team was struck by, including the scope of national power, campaign finance, the Electoral College, the Senate, and constitutional methodologies of interpretation. But let's really put on the table this question of why the audience, in your view, should vote for your constitution rather than the other side by talking about important areas of difference. So Ilya, you can direct this question to whomever you think is best equipped to deal with it. But if you had to emphasize the fundamental areas of differences between the two constitutions, what would it be? Who should take that? Timothy or Christina?
I'm going to call on Christina in a moment, but I do want to raise a couple of things. And one is that, as you said, we do devolve many more powers, have a smaller federal government, but we don't allow the states to violate individual rights in turn. We have a very strong protection for all sorts of individual rights, whether you call them civil rights or negative rights or what have you. And this beautiful language that Christina came up with about the right to live a peaceful life of one's choosing, or more broadly, the right to the fruits of one's labors. I mean, I think that's really important. And for that matter, what is currently the 14th amendment, the due process clause, or we rewrote that into privileges or immunities, which is really where natural rights are supposed to be protected. We then give the federal government and federal judges the power to enforce those rights. And we go so much as to, in our new section 14 of Article 7, constitutionalize Congress's power to establish legal causes of action, what lawyers know as Section 1983 claims. But Christina, I think, wants to expand on this and show how this is really a document to facilitate human flourishing.
Was still muted. So one of the major, differences, I think, structurally is that from what I heard in the last half hour, the Progressive Constitution is focusing more on safeguarding democracy and democratic institutions, is more majoritarian, and ours, to the degree it's less majoritarian, is to try to maintain balances of power among different power centers in order to achieve a better government. And I think at the highest level, both of the constitutions are aiming towards good governance. And I'm not sure I would even necessarily say that either system is guaranteed to be more progressive or more libertarian in its outcome. It would probably depend a lot on what the populations of people in such governed systems would, want and direct their governments towards in terms of how they ended up being. So I think that the goal here is quite interesting, and is maybe the broadest goal that we see in both constitutions is maybe very reflective of the current moment, and the concern that good governance is maybe more of the problem than particular rights and regulations. But, along similarities leading to differences, I think both and most value systems are aimed at advancing human flourishing, thriving both economically and socially. And the hard question is, what's the best way of doing that? And I think that's why I think both groups mentioned this is the way we try to achieve better governance. Reasonable minds could disagree. There's probably other tweaks we could give. That's because that question has always historically been hard for any group of people trying to achieve anything. And so the most major difference, perhaps, is that libertarians are more skeptical that kind of thriving and flourishing can be achieved through force of government rather than through facilitating dialogue, voluntary interactions among people, and trying to move those softer kinds of power through, discussion, convincing people that they should be tolerant or inclusive and those kinds of things. So it is similar goals, I would say, but a different view on how to achieve them, where, libertarians want everyone to have a wonderful life. And the idea is that we're more likely to be able to get it through a lighter touch government than through a heavier touch. But that doesn't mean that we don't care deeply about everyone thriving and flourishing.
Thank you very, very much for that. Well, why don't I'm going to ask Carolyn and then Jamal to talk about fundamental differences between the two documents, and then we'll have closing arguments perhaps from Timothy and Melissa, if that works for everyone. And friends in the audience, prepare to vote. And Tanea Topper, our phenomenal head of town hall programs, will post a poll in 5 minutes or so, and magically through Zoom, it will work perfectly, and you'll be able to cast a crucial vote. And the fate of the nation hangs on your choice. So listen very closely to what Carolyn, Jamal, and Melissa and Timothy are saying now. So Carolyn, how would you sum up the basic differences between the documents, and why should folks vote for the Progressive Constitution?
Well, I mean, I think Christina actually put her finger on much of it. Democracy is actually the way we think that people should get to choose how they want to flourish. Democracy is about we the people. The Constitution opens with that language. We think our Constitution more fully realizes the aspirations of that language, which is so inspiring, but based on a concept of the empowerment of the people to make those decisions. And so as a result, we really wanted to make sure the structures of government were inclusive and that we have free and fair elections. So the participation of all Americans can be enhanced through a constitutional structure that is protective of those essential rights. So I would turn it over to Jamal, and I'm sure Melissa probably has some comments as well about the differences.
And I'll just say, echoing what Caroline said, that, I think we're not against limited government, but we don't think of limited government as an end in itself. It's a means to an end, and we're not in favor of big government. We don't think of big government as an end in itself, but it might sometimes be a means to an end. So in that sense, I think Christina is quite right that both teams are interested in human flourishing, but at least we like to think that we're not necessarily putting our thumb on the scale of any particular means other than self-governance. That I think is an end in itself. And since the Constitution must be a constitution for all, that has to be the overriding principle. And I'll just point out one of the specific areas of difference in congressional power. I think consistent with what I've just said, we don't give Congress a general legislative power. We do give it the power, an additional power that it doesn't have now, which is there's a kind of subsidiarity principle that we've relied on, which is that there are certain areas where states might not be able to achieve objectives on their own, and they require coordination. And so Congress can step in those instances. So it's very much geared towards having a functional government that allows just the human flourishing that Christina emphasized.
Thank you so much for that. I think the poll has just popped up on my screen, so I hope the audience can see it as well. And just to keep the order even, why don't we have first closing statement from Timothy and then final words from Melissa. Timothy, the case for the Libertarian Constitution. And being called on, you feel like you're back in law school, I'm sure, but I think you're on mute, Timothy. There we go.
Sorry about that. Can you hear me now? The really essential difference is how we view the relationship between liberty and democracy. Libertarians hold that democracy is only an instrumental good. That is, it's only a good thing insofar as it serves liberty. Whereas the progressive view, as you've seen, is literally to limit individual rights in order to serve democracy. What that actually means in practice is that the state gets to eat first, and then you get whatever is left over. We think that that's demeaning and degrading to individuals as human beings and as rights-possessing creatures. We view the purpose of the government as liberating individuals to pursue happiness. And that means to enjoy the rewards of their good choices and to suffer the costs of their bad choices. If that's something that means a lot to you, then you'll support the Libertarian Constitution. If that's something that frightens you and you think that the state should, wipe your nose before you go to bed every night and tuck you in and read you a nice bedtime story, you're going to support the Progressive Constitution, which limits your freedom in order to serve the desires of the majority. That's really the fundamental philosophical difference between the two.
That was so eloquent, and we do have a little more time, and I think everyone needs a little more time to vote. And you're all so inspiring that why don't we continue with our closing statements? And I think we're back to Ilya and Carolyn. So Ilya, how about it?
Actually, Melissa was up next.
Yeah, I think it's Melissa's turn.
Oh, please forgive me. I'm so terribly sorry. She certainly was. And Melissa, please give us your closing thoughts.
Sure. I think to represent the progressive constitution as the embodiment of the nanny state is to do it a gross disservice. At no point in our modeling of a progressive constitution did we envision that the state would be all-encompassing and all-consuming in the lives of individuals. Our view is simply that democratic institutions have to work in order for everyone to be able to exercise their liberty. And we agree that the opportunity to live a good life, to flourish within our government is vitally important. I think where we may differ is that we believe that securing those prospects for everyone is as important as ensuring that they exist at all.
Wonderful. Thank you very much indeed for that. And let's continue. And who knows, maybe we'll get another full round in, because we have just a few more minutes, and this is extremely illuminating. Ilya.
Sure. A wise man said, if men were angels, no government would be necessary. If angels govern men, then I'm paraphrasing, government would be perfect, and so neither internal nor external controls would be necessary. But given the reality that men govern men, and we actually made a point to say that the male pronoun includes everyone, so read, if since everyone people govern themselves, then the first duty is to empower that government to secure and protect your liberty, but then to make it to control itself. This is, of course, Madison's Federalist Paper number 51, my favorite Federalist paper that appears on my license plate. And that's the key dilemma. Government is kind of a necessary evil that we secure to protect our rights. And democracy is, as Winston Churchill said, the worst of all systems of government except everything else. If there was a possibility to press a button and have angelic despotism, absolutely I'd go for that. Because fundamentally the key value is everyone being empowered to pursue their own vision of the good life. And so the government needs to protect their life and their liberty to do that.
Thank you very much indeed for that. 64% of you have voted already. I think then we'll have Carolyn's closing statement, and then we'll have the results. Carolyn, last word.
I just want to make 2 points. One is that, just as a footnote, I think it's interesting that as the Libertarian team updated, modernized much of the spelling of the language, rather than changing the pronoun to be gender neutral, they just mention that he should include she. I think many of us, certainly on the progressive side, don't think he includes she. They're different. And women and other genders need to be acknowledged as fully human, and not just a footnote that, by the way, men includes women. So that's, I think, maybe a very important difference in many ways. And I guess I would go back to my original point, which is that I think the real way to ensure human flourishing, the flourishing of all Americans, is to give them the choice about how their country is to be run. And that means democracy. The true protection of people's liberty and equality is a democratic system where there are free and fair elections, the government is responsive to them, and the government is effective at doing what the people want it to do. And that's what our Constitution embodies.
Is wonderfully said. I'm waiting for the results, and and they're in now, and I think you all can see them. We have 47% for the Libertarian Constitution, 53% for the Progressive Constitution. Congratulations to both teams for a close election that requires no electoral college dispute. But most of all, thank you for an extraordinarily illuminating debate. You took this so seriously and so thoughtfully engaged with one another. And I must share the fact that although some may emphasize your differences, I'm inspired by your commitment to civil dialogue and by the fact that you view our constitutional framework as one to build on rather than to tear down and start from scratch. This important project that Jeff Yass conceived of in a moment of constitutional vision will continue when we launch the conservative constitution. It's due on October 30th. Conservative teammates, that's the deadline to meet. And we'll come up with other convenings, both on video, on podcasts, with our great partners at the Atlantic and the Battle for the Constitution site, and on all the National Constitution Center's educational platforms to continue this crucially important discussion throughout this year and the years ahead. So thank you so much to all of our panelists for their wonderful work. Thanks to our great audience for your great questions. And thanks to Jeff Yass for inspiring all of us to think about first principles of the Constitution of the United States. Thanks to all. Good night.
Thank you.
Thanks, everybody.
Jeff.